think my first question is one of procedure in terms of how other states have handled this issue. Maybe it's for you, Professor Hamilton. Has the elimination of the statute of limitations or a window bill, like we have in Ms. Markey's bill, have they been done all together for the most part, or have they been done piecemeal?
Well, it depends on the state. Delaware eliminated its criminal statute of limitations in '06, and then in '07 they eliminated the civil statute of limitations and enacted the window at the same time, so in a very short period of time. A number of states don't have a criminal statute of limitations for the most important felonies, the most serious felonies, which is true in New York, the most serious felonies in New York. But for any other type of abuse that's not a sexual assault, those victims are still shut out at a very young age. Some states have just eliminated the statute of limitations without doing a window. Florida has done that 2 years ago. But there's a movement now, the pace is quickening. So right now we have 10 states with pending bills, and several of those bills are just like Assemblywoman Markey's, which is they have the elimination together with the window. So
then I guess my question is, maybe it's a legal question that you as a
Yeah.
professor can answer. Even though I'm chairman of codes, I don't seem to have the answer at my fingertips. And that is, eliminating the civil statute of limitations and having a window, do you need both?
yes, and
why?
the reason, yeah, good question. The reason is the window is only for those whose statute of limitations has expired. So, you know, I kind of think of it as an iceberg of victims that are in the state that are just silent because they can't go to court. It gives them a set period of time they can go even if it's already expired. That window then closes, and the elimination going forward really speaks to Dr. Gardner's concerns about people who are 24. Right now, New York's basically the worst state in the country, which is hard to believe, and part of the reason for that is the New York State courts, when they've been proposed theories that other states have adopted, they always say it's for the legislature. So this state is one of the worst states, and if you just do the window, you have the ongoing problem of every victim over 24 is still shut out. So you need to push it out going forward. That's what the elimination does. It's just going forward. And the window for this limited period of time tries to capture as many as are ready from the past.
The only reason I asked that question is because I think it was you, but it may have been you, Professor Director Fernandez, that said that the civil statute of limitations it would be unconstitutional to try somebody for elimination of these criminal statute of limitations.
Correct.
But not for going back retroactively for the civil statute of limitations.
In '03, California tried to do both.
Yes.
So they had both a retroactive criminal window and a retroactive civil window. The criminal window got its way up to the Supreme Court, and under the ex post facto clause was unconstitutional. The civil window is constitutional in the state of New York. There's no question about it. You've done this before in other contexts.
Mm-hmm.
So.
But I don't think a lot of people understand the distinction and the difference, even though you speak about
I think that's right.
The Constitution. And then my last question, I guess, is for you, Mr. Gardner, and that is, you seem to have indicated, even though you didn't say it, that it's easier for girls and women to come forward at an earlier age than it is for boys and men.
I don't know that it's easier. I think that so one of the problems is that when men are sexually abused, it goes against all masculine gender socialization, and they may feel that their manhood has been taken away, and so they have to redefine their victimization as something else, you know, an introduction to sex or something he had control over or whatever, and so he may not define it at all until much later, whereas some girls at least know pretty early what happened, and so for that group they may come forward somewhat earlier, but many women also wait for similar reasons, all the reasons about not being believed and the shame involved in being accused of being a seducer, which I think is even more likely to happen with a girl than a boy or a man, a woman versus a man. And I'd also like to say that in terms of institutions and what they do, I know of one case where a young man at 23 was trying to get some justice from the school where he was abused, and they strung him along, basically. He thought that they were about to, come to some justice, and he wasn't that interested in criminal charges. He wanted some recognition and for the abuser to be taken out of the classroom. And right after he turned 24, they stopped talking to him. So that's the effect of the current statute of limitations.
As I'm listening, I can't help to feel that, we're playing catch-up here. And as I'm listening to you now, and I'm listening that it's close family, friends, and relatives, or a person that has some authority over the child, I can't help but thinking about this show that they have on TV called Catch a Predator.
That's right.
Okay? And I think every one of them says, this is the first time I ever did this. If I could sell you Joe's Bridge over there in Brooklyn if you believe that one. But my question is this: knowing that happens, and instead of just looking backwards and trying to catch up, I think that it's becoming more persuasive with the internet, with texting, and I'm sitting here wondering, I don't think we have a statute on the books where the use of the internet or other electronic means with the intent to engage in sexual contact with a child. All right? So now somebody comes forward, a parent, with a text, or comes forward with an email, right? I'm thinking that would give an opportunity to get a warrant to seize certain records and actually to see where this, if there are any victims out there. So I don't know if that's something that you've looked at, something that you've heard of. I don't know of any proposed legislation looking at that right now. But especially, Professor, what?
One of the trends across the country is that a lot of states are looking at increasing criminal penalties for online activity in this arena. But your concern about identifying the predators is exactly the problem, right? Because we know that very few have one victim, including in the family. And so how do we get the information about what they've done if we've arrested them once? What's happened in, for example, California, is that one victim would file a lawsuit under the window. Now, they were barred up to that point. They'd file a lawsuit under the window, and you would see others start streaming forth. So we had one, and including in the same family. So we had one case up in Northern California where one victim comes forward under the window. His two brothers then came forward. His sisters then came forward, and it turned out that the priest had also had sex with the mother. The only one he hadn't had sex with was the father. The result of all those years of suffering, that family was completely torn apart. But my point is this: if we can just let one survivor come forward under the window, we can start identifying all the other survivors of the same perpetrator. And we can start gathering the information that you're talking about, which is we desperately need, because right now in New York, almost all our predators are flying under the radar. So, yeah.
If I can, I'm not talking about the window here. I'm talking about an additional statute.
Right, yeah.
That if you had this in addition to any charge, so if it's just a person that texts somebody, and you have a copy of the text, and it comes to the police department, or if there's email messages that a parent gets a hold of and brings to the police department, I think if we had a statute like this would enable the cops to get a warrant,
Right.
okay, to confiscate computers or to go after some of the text messages. And I'm looking at, instead of putting a Band-Aid on the wound, to try to get to the wound before it's inflicted. So I'm wondering if a statute like this would help you with a lot of the problems that are out there.
We'd like to say that the internet is the crime scene of the 21st century. And unfortunately, we've had hundreds and hundreds of years to create the laws that we have now. The internet is sort of, it's still wide open. I think that anything that allows you to get more information about your case, as a former police officer, you know that if you can get a warrant based on a series of text messages, and then you can go back and find more evidence, that's always going to work in your favor, because regardless if you have a window or an extension of the statute of limitations, you still have to prove your case, and you want to make a stronger case. So in answer to your question, I think if you can do it constitutionally, and that's always a question, yes, it can help.
I think Mr. Graff makes a good point, and you've affirmed it, Director Fernandez, and that is that it's not the park and the playground anymore. The computer is the playground of the future, and that's where you have, I mean, I'm sure you're still going to have people hanging around the playground looking for kids, but they don't have to do that anymore. They can do it right in their own living room or their own bedroom and find them. So the quicker we, older folks, and I'll speak for myself,
Thank you, Joe.
get to understand that, the better off our society is going to be. So,
If I could just add one thing, and that is that most abuse is happening in the home, in the bedroom of the child. So while the internet's a huge part of this, stranger danger is a very small percentage. The real perpetrators that's still the big taboo that we don't talk about are the incest victims.
may I commend you to, and I don't do this often enough, but Senator Volker, when he was chair of the Senate Codes Committee, and I produced through the Department of the Division of Criminal Justice Services a documentary film that is now circulating through libraries around the state, exactly how the sexual predators work. I don't know, I can't remember the name of it now, but I passed the bill,
Okay.
and you know about it, I'm sure, Professor Hamilton.
Yeah, I should say that while it's certainly true that most abuse takes place in the bedroom and is by a family member or another trusted adult, I think increasingly there will be abuse through the internet because it's so easy. And the FBI does pursue these predators. I'm not sure whether they can go just on the basis of texts. But I have observed them finding predators, well, like to catch a predator, to observe them getting into a chat room, posing as, say, a 12-year-old girl, and immediately having 5 predators approach him. Well, him being the FBI agent who was the girl. So I don't know the law. I'm not a lawyer, but it certainly has been thought of a lot federally.
Just one more note, and this is for Assemblymember Graff. As you know, again, as a former officer, you can have all the evidence in the world, but you have to have a case. You have to be able to get to a case in order to do anything. And what we're saying is you can look at the internet, and I would support anything you could do to acquire as much evidence to get these guys behind bars or to be paying out what they should be paying out. However, the focus here is getting the case forward. And without a window or without extending the statute of limitations, you could have all the evidence in the world, and you just can't move forward.
I'm looking at this as a past criminal defense attorney, too. So when I'm looking at this, I know what cases you can build upon as not only a police officer, but as an attorney. So that's why, I was careful on how I worded the statute, or just a presumed statute here, in order to give the police an opportunity, because if they violate this, a person could be charged. That would open it up to give a warrant, because then you'd have a charge of using the internet for this purpose.
Right,
And
absolutely.
that would lead to getting a warrant, right, because you can produce this to a judge. The judge signs a warrant. That could lead me to a lot more victims.
Absolutely, you're right.
The only issue then is whether the victim's ready to come forward. And basically the principle of the Markey bill is you wait until the victim's ready. You let them decide when they're ready. And many times, the police do have the information, but they don't have victims that are capable of pursuing charges right now. So this keeps the opportunity open, and the evidence is there with the police, and when the victim can do it, they can do it. So.
Thank you.
Councilwoman Markey.
Professor Hamilton, the issue of bankruptcy
Yes.
is always raised regarding every institution, and that's what they're fighting. They're saying that my bill will call bankruptcy, and can you address that issue?
Sure. The windows that have been in place have led to 2 bankruptcies total. One in San Diego, which was thrown out by the federal bankruptcy judge because the San Diego diocese had so much property and assets that they did not belong in bankruptcy court. And then the Wilmington bankruptcy, which then settled. No one has ever been put into involuntary bankruptcy, which is that you don't have any assets. The voluntary bankruptcies in those 2 scenarios are really just bankruptcies for the protection of protecting their assets and rearranging their assets to protect again and to pool all the victims together. That is a red herring. It has not no one has lost services. The best and the biggest, I guess, the biggest settlement has come out of Los Angeles, as you know, 550 victims, $660 million. That archdiocese paid all of that 50% out of insurance, 50% out of 51 properties that were not dedicated to religious use. So hotels, office buildings, apartment buildings. They didn't touch any of their religious buildings. And in fact, Los Angeles built the largest cathedral in their history during that settlement. So the bankruptcy argument is a complete red herring, and the fact is that insurance has to pay a significant portion of this, and all of these institutions have insurance about child sex abuse by their employees going back decades because they've known about it for decades. So.
Thank you.
Thank you very much. Very informative.